I am Professor Kevin Douglas. I teach one of the business enterprises classes, mergers and acquisitions, and sometimes a business ethics seminar. I usually write about insider trading, but here I'm here to help us to learn about the backgrounds of Nick and Tim. Immediately to my left is Nicholas Morgan. He's the founder of a public interest law firm called the Investor Choice Advocates Network. It's only a year old. Less than a year old, about a year old. And what they do is they provide pro bono work or services to people, small investors and entrepreneurs who might not have essentially the financial wherewithal to fight an entire case with the Securities and Exchange Commission. Try to push back against Securities and Exchange Commission overreach. And Nick has spent, believe it or not, before becoming to the private space, previously, he worked for a law firm called Hastings, but before going into private practice, he actually spent 7 years working as a senior trial counsel at the Securities and Exchange Commission, and then spent another 18 years doing private practice as a defense attorney, most recently with Paul Hastings. Tim, please help me to pronounce your last name. Is
Pagliara.
Pagliara. Tim Pagliara, founder and chief investment officer of CapWealth Advisors, which is a registered investment advisory firm in which part of Tennessee?
Franklin, Tennessee, right outside of Nashville.
Right outside of Nashville. And he's registered on the Investment Advisors Act and advises and manages the funds for clients of over $1.6 billion. He got into the business in the year 2000, so he's been doing it for over 20 years now. And way before that, Tim became a licensed attorney and graduated from the University of St. Louis. So will you please thank them both for taking the time to come here and share their So we're going to start with a short description of what the Securities and Exchange Commission does, or your interaction with it.
Right. First of all, thank you for having us. I'm from Los Angeles, so you've already heard one of my preconceived notions about MSU. You guys have beautiful weather. I don't know what the reputation for cold weather in spring is. But I think, so to give a little bit of background, I think will help for the topic we're going to talk about, which is the SEC, and the SEC is not alone in this, but their propensity for regulating by. We'll break that down. But when I was at the SEC and afterwards defending people against the SEC, one of the patterns that I noticed was almost everybody who gets sued by the SEC settles with the SEC. It's very expensive. I left Paul Hastings, our hourly rates were $2,000 an hour. And, if you're a small investor, a small entrepreneur who has an SEC matter, it's important to understand what the process of dealing with SEC, either enforcement, other divisions, entails to fully understand the cost of dealing with the SEC. So in an industry like Tim's, the registered investment advisor industry, you're a regulated entity, which means you directly have to file reports and subject yourself to exams with the SEC examination staff. So the examination staff is like auditors. They come by on a regular basis and examine your offices, not necessarily for cause. It could be just a sort of routine exam. They stop by and ask you a bunch of questions, interview people, review a bunch of documents. Sometimes those examinations get referred over to a different division of the SEC, the Enforcement Division. Enforcement Division has, before there's any litigation, has the power to subpoena documents and testimony from you and third parties, banks, brokerages, investors, anyone they want. They can send subpoenas to. This is all before there's any litigation. Average pre-litigation investigation by the SEC is about 2.5 years long. So that may not mean much, or there's no context for you to understand the meaning of that, but if you're trying to run a business and you're, through your counsel, getting calls and responding to subpoenas over that long a period of time, it's very disruptive. And a lot of investigations get closed and there's no enforcement action brought. And enforcement action is the next step. So a small percentage of investigations turn into litigation. And Tim's going to tell you a story about his with the SEC. But so from the first day of litigation, the SEC is only a civil law enforcement agency. They rely on attorneys' offices to enforce criminal repercussions for federal securities laws violations. So the SEC can initiate an action in federal court, civil action, or initiate an administrative proceeding in its own courts. The average length of litigation that doesn't settle, most do settle, either right away or in the next several months, at the inception of a lawsuit, can be several years. We currently represent, as Tim mentioned, we provide pro bono law services to people who have been sued by the SEC or counsel. 3 of our clients, and we might get into this case, have been litigating with the SEC since 2015, so 10 years. And we're not done. We're on appeal to the Ninth Circuit. So you can imagine if you're talking about an examination that can go on for months, an investigation, pre-litigation that can go on for 2.5 years on average, and then litigation that can go on for a long time. Not always 10 years, but it can be years. All in, that is a very expensive process. People tend to settle with the SEC, and we'll talk about the ramifications of that phenomenon later. But I think that helps to understand kind of the process of touches with the SEC.
All right, perfect. Thank you. And feel free, when we get to the Q&A section, feel free to ask for questions related to details about the process and how it affects investors and entrepreneurs. But we wanted to jump into specifically Tim's experience with the SEC after about 20 years of providing services to, wanted to first get into your background, how you got into the financial advisor, business, and what your relationship was like with the SEC before you actually had problems with them in the year 2020.
Great. Well, thank you, Kevin, and it's really great to be here. I look out into this crowd, and after scanning the room and everyone that's here, I'm absolutely convinced that I probably graduated from law school with the lowest grade point average in class rank of anybody that's here. So there's hope for anybody. So I started my career at Edward Jones and Company. I worked for them as an intern while I was in law school and graduate school. I wrote their Series 7 program. I never wanted to practice law. I was always fascinated with the law. My heart's always been with the business side of things. And I found a way of melding the two together. I stumbled upon an assignment that I got. One of the partners in the firm was doing investments for Bob Forsch, who was a pitcher for the Cardinals. And he was taking over for his agent, who had put him into a lot of shady investments, commodity tax straddles. He had just signed, for the baseball fans in the room, the largest contract in St. Louis Cardinal history, $450,000 a year, 2-year contract. I think they get that per game now. And they brought all this over to me. I'm a second-year law student, and he had been committed, his agent was defrauding him. He had him in this commodity tax straddle that had no business purpose. I told him he was going to get audited. He didn't like that because what I didn't know as a second-year student is that in agency, he was a family friend. So I was like accusing his uncle of defrauding him. Not a good look. And so after he got mad, left the room, the partner looked at me and said, "Well, you screwed that up, Pagliara." And I went back to my cubicle and hid out. Fortunately for me, a couple of weeks later, he came back. The IRS had audited him, and they had disallowed all of those deductions. And he was panicked. I said, "I'll have an appointment set up at my security law professor's law firm." It was Gallup, Johnson, Gardner, Morgenstern, and Krebs in St. Louis. I'd worked for them as a first-year student doing menial things. Wrote a memo, walked in the room. They had the managing partner of Arthur Anderson there. They had 3 litigators. Everybody wanted to meet this guy, because everybody's a baseball fan in St. Louis. It's worse than the Cubs in Chicago. And so, I was right. Got this guy banned from sports. Had a lifetime friendship with Forsch. And I was leaving the room, that hit me. You control the client, and you add value, you can do something, really important. And so I stayed in the industry at various different capacities, representing and working with clients, started my own firm in 2000. And the case we're going to talk about is the SEC versus CapWealth Advisors. Tim Pagliara, Tim Murphy, they also sued one of my partners. And it's case number 3-20-CV-01064. It's real easy to pick it up on the internet. And the issues in the case had to do with disclosure. What is adequate disclosure of the fees that you collect in a relationship with the client? And there were different components to that. We charge an advisory fee. We manage now $1.7 billion on a discretionary basis. At the time this case was filed, December 11, 2020, we were managing $1.1 billion. And for our smaller accounts that have mutual funds, there's additional costs in there embedded. So there's a management fee that the mutual fund company has, there was a custodial fee, and then there was a distribution fee where we managed the relationship for the mutual fund. So the issue was over the disclosure of the fees that we received in that relationship. The industry was responding to noise that the SEC was making about these disclosures, and they wanted the practice of the 12B1 reimbursement to end. And we were in complete agreement with them. Once the industry went from the F1 shares, where we were collecting a fee and the custodians were collecting a fee, we discounted that fee, and I'll tell you why in a minute. Then they went to F2 shares, where they eliminated our advisory fee but kept a custodial fee for Charles Schwab. Then they went to F3 shares. And the process of converting client shares, when you're talking about hundreds of millions of dollars, it doesn't just happen overnight. The SEC was forcing these conversions overnight, not in the best interest of clients, because they lost an important tax benefit. It's called last in, first out. And by forcing this conversion, everything had to go to average cost basis. So clients that had mutual funds with no cost basis from years ago that they'd paid tax on, they were losing the benefit of that last in, first out. So it's one of the things we argued in our litigation very successfully in front of a jury. So we had made the decision to end that practice, and we had exited that part of the business by 2018. They came in with their investigation in the latter half of 2019, and by the December of 2020, they had filed the litigation against us. It didn't go to trial for another year. So, to Nick's point, these are long, drawn-out things. So they started with a formal investigation, and in order to beat them, you have to be prepared. And fortunately, my background as a lawyer and helping other clients with litigation and advising them over the years, an ancillary way to the investment management holistic practice that we had, it kind of equipped me. So I hired one of the best litigators I've ever worked with. His name's Gino Bolso out of Nashville, Tennessee. He's done virtually all kinds of Consumer Protection Act work. He just sued 5 California car dealerships on the behalf of Nissan USA and got the largest judgment in Tennessee history, $138 million. He's already collected $120 million of it. They were defrauding Nissan. I hired one of Nick's partners, Brad Bondi, as a consultant. He was $1,700 an hour at the time. His associate was $800 an hour. My attorney was $650 an hour. So that tells you the difference between Nashville, Tennessee and being in Washington, D.C. And then finally, we hired Professor John Macy from Yale University. And both of those guys helped us in understanding the inside of the SEC.
Tim, can you tell us, you talked about the idea that the industry itself wanted to change the fees that were being received by investment advisors, so that instead of these 12B1 fees where, to the extent you put clients into a particular mutual fund, you yourself or the advisors would receive a fee, you're saying the entire industry wanted to step away from that model. And the issue is around the disclosure about the fees. what was the SEC's awareness of the fees before the industry even decided that was a problem? In terms of how aware was the SEC of the kind of disclosure you were making before they wanted things to change?
I may have misspoke a little bit. The industry was forced to change because this is what the SEC wanted. And when you look at the 12B1 fees that the clients were being charged, it's a tax issue. And again, this is part of the background that I had from being a lawyer. Those fees are fully deductible as an ordinary and necessary business expense inside the mutual fund. They're not deductible by the client. So advisory fees at the time were subject to the limitations of 2% of adjusted gross income. So for my clients that didn't file, that just filed standard deduction, they were not able to deduct those. And for my wealthy clients, they were not able to deduct them either because typically didn't have enough of a threshold to be able to capture them. So the SEC was forcing the industry into a very inappropriate tax disadvantaged position for investors. But they didn't recognize it, and we did, and was one of the arguments that we made very successfully to the jury. And so they eventually charged us with violation of 2064, which prohibits any investment advisor from engaging in fraudulent and manipulative conduct and not acting in the best interests of clients. So this is what Nick's talking about with rulemaking enforcement. That's a term of art. What does that mean? Well, they defined it the way they wanted it defined, and then took steps along this process of settlement, making it so difficult that people wouldn't challenge them. The second thing they charged us with was violation of 2064-7. That's an obligation we have to have written policies and procedures. It's a manual. And they said that our manual wasn't adequate to keep us from engaging in fraudulent, manipulative behavior that's not in the best interest of clients. Now think about that for a minute.
And to be clear, the practice that they described as a fraudulent and manipulative practice that wasn't in the best interest of your clients was the way in which you were disclosing these fees received from the mutual funds, correct?
That's right.
But how long did the SEC, how long were they aware of that fee structure that was in place?
Well, they did our first audit with my firm, newly formed firm from 2000. They did it in 2011. It was a very clean audit. They were very constructive. They were in my office for 2 weeks. They gave us the disclosures that we used all the way through to when we shut down our broker-dealer in 2018. And they said, well, they're no longer, they're not adequate. You should have changed them. This is like.
Can I interrupt you for a second? So you're talking, when you say they came in and audited you, the they there is the SEC examination staff, right?
Examination
Not
staff.
enforcement. The people you were dealing with later was in court and in the investigation enforcement.
That's right.
And one of the issues here is those two parts of the SEC can take totally different positions. And you can't rely on what the exam staff tells you to avoid litigation with the enforcement staff. And if I could just give a little bit more context, I think this goes to your question on this issue of how to disclose these fees by an investment advisor to the investment advisor's clients. This was an industry-wide issue. Everyone was disclosing them in the way that Tim's firm was disclosing them. The SEC Enforcement Division decided those disclosures were not appropriate. And what they did was, I think what we're trying to talk about here, is instead of promulgating a rule under the Administrative Procedures Act, putting it out for public comment and notice and all that, rather than going that path, they started suing firms like Tim's. And I don't want to let you finish your story, but for the vast majority, 99+% of the firms that were approached by the Enforcement Division about this issue, they all settled. They paid a penalty, they agreed to change their disclosures, and they didn't admit the truth of the SEC's allegations, and they moved on. And so you were the outlier in that.
I was the outlier.
But there were dozens, if not maybe 100 firms that settled with the SEC on this point.
I want to add one more cherry in case, to put a bow on this point in case it's not clear. The investigations division actually helped you to write the disclosure that the enforcement division later said was fraudulent. So in the years 2000 and the years 2011, the investigations division looks at the disclosures that you're making to your clients on a yearly basis, says, okay, good job. They leave. And then 7-ish years later, the SEC wants to change things, and 2 years after that, they charge you with having defrauded your clients by including a disclosure which a separate part of their organization said was good to go.
That's correct.
Okay, that's the.
And prior to the actual selection of a jury, as you're going through this process to get to that point, in a jury trial, there's a thing called motions in limine. And the SEC filed motion after motion in limine trying to exclude the fact that the examination division had already blessed these disclosures that the enforcement division had found inadequate.
Did they keep them out on the motion to eliminate?
No, and they tried everything in the book, and then in the examination from 2011, there's a catch-all provision at the bottom of the letter. And the SEC attorney, when I was on the stand, said, read this to the jury. And it says, just because we didn't catch something doesn't mean that you get a hall pass and you're not guilty of something. You know, even after it was very clear we followed the mandate, the directive was very cooperative in the disclosures that they had told us to make in 2011. So, you know, at that point, when this process started, in the middle of COVID, I was spending $100,000 a month on average on legal fees to get ready for this trial. It cost me over $2 million in hard legal costs. Fortunately, I have this amazing team of people. I employ 2 CPAs, 3 chartered financial analysts. I'm an attorney. We were our own expert. Putting a price on that would have been at least $500,000 or more as well. In addition to what Nick said, the disruption in the business. So how do you beat the SEC when you're going through something like this? Well, the first thing you do is you attack them directly. We were not the ones that were not acting in the best interests of our clients. It was their poor interpretation of the tax efficiency and the deductibility of these 12B1 fees. For the clients that we're really supposed to be helping, is typically the small investor that can't get the diversification and need to own mutual funds. Their policies were adverse, and we took it right to them with the jury on that. We had discounted our advisory fees to account for the collection of this 12B1 fees, in addition to the disclosures we made. And there was $528,000 worth of fees in question. That was less than 2% of our revenue during the 3-year period that was in question. So it was de minimis to begin with. By the time we applied the discounting policy to all of that, there was $40,000 of fees in question. You know, the SEC had 8 lawyers, 2 experts, and 2 jury consultants against what I was spending at $100,000 a month. So you can just calculate.
So hit pause for emphasis there.
Yeah.
So you spent $2 million on the trial over an issue that involved $40,000 worth of fees.
That's right. Right.
And you're gonna, another, I think, brilliant thing you guys did was to raise sort of the counterfactual. Like what was the disclosure? What would the SEC have dictated the disclosure be?
It all came down to the difference between the word may and shall. They said we should have used the word shall instead of the word may. Now, why did I use the word may? Because my compliance consultant told me to use the word may, and because the SEC had reviewed and blessed it in 2011. And why was may appropriate? Because the only way we collected a 12B1 fee is if they were operating inside of our broker-dealer, which we had shut down in 2018. By the time this case had been brought, we hadn't collected a 12B1 fee in 3 years. So may was appropriate on a factual basis based upon how we were conducting our business. We were agnostic as to where clients custodied their business. And so that was the other factor with it. So the next thing we did, we destroyed the credibility of their experts. And this is one of those things, we got calls immediately after this, especially Gino, from attorneys that said, oh my gosh, that was the same expert we had. I just wish my client had had enough money to challenge it because we were never able to take his deposition. So what did we do? Well, this guy he was managing a registered investment advisory firm with $11 million under management. And his partner that helped him write the expert opinion for the SEC, he had 2 undisclosed civil violations, civil judgments against him. One was a personal bankruptcy that he was required to take a financial planning course to satisfy the needs of the bankruptcy court to exit bankruptcy. None of that was disclosed. And we put him on the stand. He wouldn't tell us how much he was paid, but we knew he had been paid over $500,000 on retainer at the SEC for the previous 2 years. And so we do video deposition. When you get into that part of discovery and understanding how to take a deposition, watching a technician like Gino Bulso is an amazing thing. That's how you guys really learn. And he took one little thread from that video deposition and he waited till he had this guy on the stand and he'd been questioning him for an hour. And the guy lied, completely contradicted himself. He said, no, I never said that. Well, let's play this section of your video deposition right in front of the jury. And it was clear that the guy lied. He just made up a story in front of the jury. And all of a sudden he breaks down and he says, oh, I was having a really bad day. I'm diabetic and I think my blood sugar was low. The judge said, I think it's time to take our afternoon break. And he let the jury, escorted them out of the room. Now, you can't make this stuff up. The second expert that they had, he testified right after him for about 2 hours. We broke for the day. And the judge gives instruction. You're not to discuss. You're still under oath. You can't discuss this. It's called the exclusionary rule. You can't change your testimony. You can't discuss your testimony to improve it. First thing this guy does when he gets back on the stand, the next morning, says, well, Your Honor, I want to make some corrections to my answers to the questions that I had yesterday. And I'm saying, oh my God, here it comes. And the judge, his body language goes like this. And he says, did you discuss this matter with anyone after I told you not to yesterday afternoon? Well, no. If there are any one of you 8 attorneys that had any discussions with this gentleman about his answers to the questions from yesterday afternoon. No, Your Honor, no, Your Honor, no, everybody's knowing Your Honor. And then he says, bailiff, would you have the jury escorted from the room? And then he gets serious. And finally he asks this guy, he says, how many times have you testified in federal court? Well, Your Honor, this is my first time. And he goes like this, and he says, bring the jury back. Came that close to holding them in contempt of court that day. And then finally, it was the SEC destroying the SEC. They went through my entire client base trying to find someone that would testify against us, that our disclosures weren't adequate, that we should have given more disclosure. And they had an 80-year-old woman from Lilburn, Georgia, that they brought up to testify. I had managed her parents' money, family money for 20 years. They died. They distributed the money to the heirs. They went back to Lilburn, Georgia. They brought her up to testify. She was on the stand for an hour. Gino gets up and he says, Ms. Lampley, has anybody explained to you why you're here? Well, no, not really. Would it surprise you to know that the amount of money in question that the SEC brought you from Lilburn, Georgia to Nashville, Tennessee to testify was $67? Yes, that would surprise me. And they paid your airfare, they paid for a hotel, they paid for your meals, and now you know that it was for $67. I have no further questions. The SEC attorney stumbled. Sometimes the best thing you can do when you're digging a hole is to stop digging. She got up off the stand, walked by me, and in front of the jury, gave me a hug. That didn't go well for him. The second client that they had testify, he just kind of fumbled through it. And ironically, back in December this year, he called me, he apologized, he said, "You guys never did anything wrong. I hope I stumbled through that, but I felt pressured by the SEC." You know, when they talk to my clients, they basically Mirandized them before the discussion even started and intimidated them and said, "You know, you can go to jail if you don't tell us the truth. You better tell us the truth." And so the whole process was intimidating. And then the final thing that we did, and this is something really good for all of you to know, you know, you're going to take civil procedure, learn the federal rules of procedure. The federal rules of procedure is not something you just memorize to get through the course and get a grade. It's a weapon in litigation. And the SEC lawyers were so deficient in the federal rules of procedure because they had litigated so few of these cases, to Nick's point, that the judge sanctioned them finally sanctioned them for violating the federal rules during the pretrial motions, forced them to affiliate an attorney from the U.S. Attorney's Office to review every motion to make sure that it complied with the federal rules of procedure and the rules of his court. So what'd they do right afterwards? They violated one of the rules of his court because they called his clerk in an ex parte communication under his rules, wanted clarification for the rule he just did. So it was embarrassing. What kind of credibility did they have with that judge at that point? They had virtually none because of the way they conducted themselves. You know, so it was an amazing experience. The trial went on for 2 weeks. It took the jury 35 minutes to undo everything that they had done for over 2 years and probably costed out over $8 million of litigation. So, you know, that's the danger of rulemaking enforcement and not having collaboration between the SEC as a partner in the industry that has to operate.
Nick, can you take maybe 5 minutes to put a bow on what you think, what your overall concern as it relates to rulemaking by enforcement in general, and or specifically what happened in Tim's case before we go to the Q&A?
Right. So Tim's case is unusual in that he went to trial, also unusual in that he won at trial. It's not unusual, though, the phenomenon that he and others in the industry faced, and that is the SEC decided they wanted disclosures to go from may to shall, or may to do, did, and they have, instead of promulgating a rule, which they also can do, and you put it out for public notice, public can comment on it, you can modify it, you can finalize it, they decided to pursue that policy change by case-by-case litigation. And the reason that I founded ICAN, the public interest law firm, is because not everyone is blessed to have Tim's resources to be able to spend that much money. And so most people settle because they can't afford to fight, even cases that are meritorious. And so the problem with making what I call shadow rulemaking, not through the APA, but through this case-by-case enforcement mechanism, is that the SEC settles and settles and settles, and over time aggregates a bunch of what it views to be precedent. It's not precedent, but precedent, and that becomes the law. And so I'll stop there, but I have more to say on that topic.
Okay. I'm going to ask one question and then potentially open it up to the audience in case you guys have some, but I'm sure, how many students here have taken an administrative law class or are in an administrative law class now? Good. I'm sure our students in the administrative law course have come across a case called Chenery 2, in which the court, which is also about a case with the Securities and Exchange Commission, but instead they're talking about a phrase called policy change through adjudication. And it gets a similar kind of stamp of approval and seems to have been supported since about 1947 by judges on all sides and in all stripes, shapes, and colors. Is what you're talking about when you talk about regulation by enforcement, how does it relate to or connect with this policy change through adjudication, similarities, overlaps, differences?
Yeah, it's the same thing. And so frontal assaults on the practice of regulation by enforcement are difficult to make. The topic has come up very recently and very vocally from members of the cryptocurrency crowd fighting the SEC. And they have tried different sort of legal maneuvers. One is sort of a fair notice argument, and the Chenery opinion, if I recall correctly, had to do with due process concerns. So it's pretty well settled that the SEC may operate in this way. The cryptocurrency industry did not get a lot of love from the courts on its fair notice arguments. It's just kind of make the same point. So I think it's a policy we're stuck with, and it has some positive benefits to it, but it certainly is unfair for a lot of people and doesn't provide the same kind of notice that rulemaking provides.
So one, but I guess two separate follow-up questions. What do you see as the positive benefits to that approach to rule change or policy change? And second, what's the SEC and other agencies, what's their take on why it's a positive thing and in the best interest of the public and the folks they're charged to protect?
So I think the positive aspects are, if I imagine another world where the SEC tried to do rulemaking for every single aspect of every industry that comes within its jurisdiction, that would not be an appealing an appealing world. We would just have rules on all sorts of minutiae, which is not a good place to be in. So I think there is this is a good use case of British common law, the idea that we look at old cases and we have a new situation and we're going to apply the old cases to this new situation. So I do think that flexibility, and this is what the SEC cites in favor of regulation by enforcement, is the flexibility to take new positions when new fact patterns arise. Okay. So I do think that's the benefit of this process.
Any chance you have a concrete example? Something that makes sense to you as like a change that happened in the financial industry, and it's good that the SEC just said, hey, these anti-fraud provisions prohibit this new thing, as opposed to saying, here's a new rule for which we're going to regulate this new behavior?
Right. Well, I actually think that the policy change Tim just described didn't necessarily require a rule change. It also didn't require a case-by-case litigation. So the SEC has other tools at its disposal, no action letters, 21A reports. It can signal policy changes short of litigation. So I think that's a good example where a rule saying you must use the word did instead of may, that wouldn't make any sense. But those aren't the only two options, APA rulemaking and litigation. There are other tools at the SEC's disposal.
And let me know if this is one of the other tools you had in mind. You were talking about the inspection division interacting with Tim for years before the enforcement division comes and bothers him and says, you've been committing fraud. I'm assuming an example would be the inspection division could have said, hey, we've changed our mind. We don't like this anymore. Please do it this way.
Or turn that on its head and say that parties who have been through an examination by the examination staff are entitled to rely on the statements made by the exam staff.
I mean, if they want change. So
if they want change, right.
Have the exam staff say, hey, we changed our mind. We don't want you to do it that way anymore.
And the SEC has a tool they use once every few years. They put out a 21A report where they tell everyone, we are not suing party X, but what we're saying is what party X did is not good. So we're putting the rest of the world on notice that it would, to the extent you think our policy was what they were doing, we're not suing them, but going forward, you will get sued if you do what your company is. So they have other tools.
Another variation that, of this that came up, the SEC, when they made the decision, they wanted to eliminate these 12B1 fees. They created the amnesty program. And the amnesty program was a self-reporting mechanism where you could go forward and say, I'm sorry, I violated these rules. And they agreed to give you some mercy in forms of civil penalties, but you were gonna have to disgorge 100% of what they thought was subject to self-reporting. And they actually tried to use that against us also in the initial examination, and then when it was referred, they said, well, why didn't you self-report? Well, I didn't do anything wrong. You know, and that became, again, one of the hammers that they used, that again, it's so dysfunctional. And I would make the point too that, look, there were some bad actors in my industry that used these 12B1 fees against clients. They used them in a way that wasn't in their best interests. They had policies and procedures that they had to use the highest share class, and they had to not discount their advisory fees. SunTrust Bank, who, in my opinion, got away with murder, one of the first settlements for $5 million, they collected the 12B1 fees, their advice separately, and they required their advisors to sell 12B1 fee related mutual funds. And the advisors didn't even know that they were not collected. They never saw their payout grid, so they weren't paid a dime. It all stayed with the house. That was clearly not in the best interest of clients. They paid a $5 million fine. It probably could have cost them as much as $50 million if they hadn't settled it. So the settlement thing, some of the magnitude of some of these things is so big in some of these firms that they also settle because they're probably going to lose anyway, and it's more efficient. And so the whole thing is just terribly, terribly dysfunctional in the really ending up with a system that works in the best interests of clients.
Any questions from the audience? Good.
I believe it's Mr. Pagliano, if I said that correctly. You mentioned that the attorneys for SEC received sanctions for pretrial matters. Do you recall exactly what they were sanctioned for?
They were sanctioned for their failure to follow the federal rules of procedure consistently and the judge's local rules of court. And he removed that sanction on them right before the trial started so that they would not be prejudiced in front of the jury. And he still chewed them out, but he chewed them out when the jury wasn't present. And it was for a whole host of things. Their pretrial brief, he said was terrible, inadequate. I mean, it was like having the worst day you guys would have with a professor that was reviewing something that you written that they didn't like. And I mean, they didn't pull any punches. This judge was great. Judge Waverly Crenshaw. And he actually ordered the trial to stop right before Halloween. Jury was a little antsy, so he dismissed them early so they could be with their families. He ordered the fourth mediation. Now, this gets into the whole theory of under what rule did the judge have the right to do that? And there isn't any that we could ever find. When you're a federal judge, you can do just about anything. It's another reason why you want to maintain your credibility if you have litigation in front of them. And that went nowhere, either. So, and he reminded the SEC, he was begging them basically to get this thing settled. He says, at the end of the day, I'm the one that assesses damages, even if there is a guilty verdict here. And even if you prevail, I'm the one that's going to determine how much damage is assessed against these defendants.
Was there going to be a follow-up? Or that was your full question?
I guess I was just curious if there are any discovery sanctions against the SEC or if that was...
This is one of the really strange things that Nick kind of alluded to. In normal litigation, you file a pleading, you start discovery, then based upon what you learn in discovery, you've got the ability to file amended complaints. And that process goes on until the close of discovery and you go to, summary judgment motions. And in this case, they got everything. I mean, and we are in front of a regulator, in litigation, we've got the ability to object to discovery. It's overly broad, not necessarily going to lead to, anything productive, all those different things that you can do. We couldn't do it because they could shut us down. The minute we said no to a discovery request, they come in and shut the doors on us.
So if I can put a little color on that. So during the investigative phase, when the staff has subpoena power, there's no judge. Theoretically, you could go into court, some judge, file a new action to quash an SEC subpoena, but there's no real established mechanism to challenge an investigative subpoena. So these subpoenas tend to be super broad. And of course, theoretically, when I was trial counsel at the SEC, it was great to be litigating a case where someone had conducted a full investigation with subpoena power for years. You theoretically shouldn't need any discovery in the litigation because it's all been done. But it puts firms like Tim's in a terrible position during the investigation where your primary regulator is giving you a subpoena for every piece of paper that you have, and it wants to talk to all of your employees on the record, and you really can't say no. There's just no mechanism, as opposed to litigation in court under the federal rules of procedure, where you can go to the judge or the magistrate judge and file a motion to quash or a motion to narrow the discovery. You don't have that during investigations.
They did this with your clients too. They had the phone numbers and account numbers of every client that we had. I'll never forget, when this process started, I have such great clients. They called me. One of them was an attorney. I mean, he kept notes of everything the SEC was doing and, the whole process of entrapment. They called this 84-year-old woman. I had taken care of her and her family and her trust for about 25 years. And you can imagine she was so upset. Her daughter, who was operating her account under power of attorney, she called us. She had to give her mother a sedative, and and was just enraged at what they were doing. But that's the kind of stuff that you have no recourse whatsoever. And they just kept pounding and pounding and pounding. Our count was that they had interviewed almost 50 different clients. And the two that showed up, turned out to be a disaster for them. No one else had any complaints.
One question in the back, Professor Samard.
I was curious if you want to talk a little bit about the incentives of the SEC. I mean, it's curious, why, if the goal is to change these practices, why not use one of the other means that you're talking about, the letter or whatever else? What are the incentives for lawyers at the SEC? Is there something about, hey, we get a bunch of cases, we can win them, that looks good, these seem easy for us, or what do you think is operating there? Is this, and talk more about how that shapes the whole
Thank you.
situation.
So if you couldn't hear, what are the incentives that give rise to this phenomenon that we've been talking about, and how you might change that? So that's an open-ended, that was perfect for but before Tim talks about his particular issue, within the enforcement division, individual attorneys and offices get credit for bringing new enforcement cases, not opening investigations, not closing investigations, and the credit you get is for bringing a case. So you sort of get the 1 point for bringing a simple case. You get 1 point if you bring the next Enron case. So the incentive internally, and this is, I experience this, is to bring as many cases as you can. That's the incentive. If you lose a case in court, there's no disincentive pushing back that would cause you to want to not bring bad cases. So Tim's very interested in the possibility of recovery of attorney's fees as a potential disincentive for bringing bad cases. There is something called the Equal Access to Justice Act that theoretically allows a party prevailing against the federal government to recover fees. I will tell you, in the last probably 10 years, there's an annual report that comes out that says how much each agency has paid. The SEC has paid $0, and that's largely because people don't pursue these fees, and the burdens on establishing an EJA claim are very high. So the number of cases where the SEC has paid EJA fees is very low. But Tim has thoughts on that as well.
No, I'll be working with Senator Haggerty this year. He's on the Senate Banking Committee to explore the legislation that would require the prevailing party in an action like ours, the SEC, if we prevail against them, they pay our attorney's fees. And then you have an automatic peer review of the action of, the enforcement division, step by step, how they conducted themselves, why they were wrong in the eyes of the jury, what they could have done to improve the process, all those things that I think would lead to a much more balanced system than what we have now. Because it's a terrible process. I mean, Nick, you know more, you could explain it or better than I could. I mean, from the point where you get a Wells notice, where you've acted responsibly and with distinction in your industry your entire life, and they give you a notice and tell you that you're now under formal investigation as a prelude to the SEC filing litigation, you've got a certain series of rights. But at the worst end of this, they're going to try and ban you from the industry you've worked in for life.
And even if you win, even if you win, the reputational damage really can't be undone. If you Google Tim Pagliara and CapWealth, the first thing that's going to come up is the SEC's complaint that they filed. Not the jury verdict. Maybe you'll dig down deep enough, you can find the jury verdict, but that's pretty hard to overcome. And that's for clients, when I was at Paul Hastings, who settled, their biggest complaint is not having to pay a fine or settling or complying with the restrictions imposed upon them. The biggest complaint is their reputational damage. Like, hey, I don't think I did anything wrong. I am settling because it's prohibitively expensive to litigate, but I'm going to lose a bunch of clients because they're going to assume I did something wrong. So it's the reputational damage.
Professor Stashevsky?
Go ahead.
So given the skewed incentives to bring claims instead of win them, combined with the high settlement rates, do you think that Loper-Bright decreasing the level of deference to agency statutory interpretations will really have any practical effect on this shadow rulemaking?
No, and at least not in the SEC context. I can't speak for other agencies. But the SEC generally did not try to take advantage of Chevron deference. There are a limited number of cases. I can think of one, actually it's an insider trading 10b5-1 case, where they specifically asked the court to defer their judgment in the face of an ambiguous statute. For the most part, the SEC, I don't know if this is hubris or what, but they come into court saying, we're right, this is what the statute says, and we should win. So I don't see that Loper-Bright will have a big impact on this practice.
John?
Back to the incentives discussion. So in this particular case, is it an incentive that, given that most of these cases are settled and not taken to trial, even if this trial in particular was pretty expensive for the SEC to conduct, on the aggregate, they could have made money, brought in money, right? If they settled with SunTrust for $5 million, others for multiple millions of dollars, is that an incentive? Because for someone in an upper level, not just someone filing cases, but an upper level, because they brought in more money?
Bringing in money is not so much of an incentive.
And then also they can, through these settlements, promulgate this rule.
Right, well, so I think that's a policy incentive. You can nudge the law in this direction by doing repeated settlements with parties. Announcing a settlement of a payment of a penalty and disgorgement is helpful. There's a whole other discussion on the difference between what the SEC announces parties have agreed to pay and what they actually collect. There's a huge delta there. So the money collected from investment advisors, say, in payment of disgorgement and penalties goes to the Treasury, not to the SEC. So there's not, like you might have a local sheriff's asset forfeiture situation, there's not a financial incentive to bring in money. It doesn't increase the SEC's budget, but it helps us sort of from a PR perspective.
So basically, when the annual report goes out, the more penalties you've had people agree to pay or have imposed on people, the better the SEC looks. So to the extent that it creates a positive view, there's that incentive only,
Yes.
not the civil asset, not the suspect one of we get rich. Last question.
Yeah, so as far as the cost of this type of litigation, I was wondering, one, how do you just sustain a pro bono practice in it? And two, knowing what you know now about getting a positive verdict, but also it costing you $2 million and likely not receiving any attorney's fees, do you at any point wish you settled?
No, my integrity is not negotiable, period. And fortunately, I had the money to fight them, the personality that kind of accompanies that. And, you know, when you look at JP Morgan, for example, during Jamie Dimon's tenure, he's recognized as probably the best CEO of our era in banking. They have paid over $20 billion in regulatory fines. So typically a company where you're not, the company is separated from the individual reputation, they don't sue Jamie Dimon, they sue JP Morgan. They do a cost-benefit analysis of their reputational risk in court. And so they have chosen this path of settlement because it clogs up their business and it costs money, and they can't afford the reputational risk of things that will make them look bad in the communities that they serve. And that's what happens, you know. And so the smaller you are, more important your reputation is. That's all you've got.
And then to the other part of your question, sustaining a pro bono practice, given the cost, step one is to find somebody idiotic enough to step away from a law firm partnership to do it. Step two is there is no better donor base, I hope this isn't giving away too much, than people who've been put through the ringer themselves and who want to make sure other people don't have to go through that without counsel. And so we rely on, you know, we're a 501c3, we rely on tax deductible donations. And I will say, many of our donors are people who have been through the SEC ringer and don't want other people to go through it alone.
And I will donate to Nick as long as he's got the energy to maintain this practice.
I'll call you after.
Thank you all so much for sharing with us.